number 56, the people of the state of New York versus Sergio Cerda. Counsel?
Good morning, Your Honors. May it please the Court, my name is Donna Aldea. I represent Sergio Cerda, and I would respectfully request 2 minutes rebuttal.
You may.
Your Honors, this case arises at the intersection between the rape shield law and the constitutional right to present a defense. In this case, the trial court's rulings, compounded by the prosecutor's use of those rulings on summation, ultimately deprived the defendant of the ability to provide a defense in this case.
How many rulings are we talking about?
Excuse me, Your Honor?
Do you have specific rulings you want to point to, or is this a cumulative effect of many rulings?
So it is a cumulative effect of many, but the one that I want to focus on specifically is the preclusion of the DNA and serology report. So in this case, I think that the DNA and serology report was the most probative piece of evidence that supported the defense that the injuries in this case, which were absolutely essential to corroborate the complainant's account, had actually had an innocent alternative explanation. So what the DNA and serology report would have shown, and what counsel proffered to the court, was it would have shown that the complainant's own saliva was found in sufficient quantity to be detected on her vulva and on 3 stains on her underwear, which would have supported his defense that the injuries, the petechia that were observed, could have been caused by masturbation or by her self-rubbing. It also
Could
showed...
a jury permissibly arrive at that conclusion without engaging, and again, this is what I think the trial judge was getting at, in speculation?
Yes, Your Honor. The jury could arrive at that conclusion because obviously if that report had shown, if the report had been admitted into evidence, what it would have suggested or what it would have shown is the presence of saliva in sufficient quantities for detection in those areas under these circumstances where all that was alleged was digital penetration would have strongly suggested or corroborated the defense that the complainant had either rubbed herself or had inserted something self-lubricated and inserted something herself into her vagina.
Well, but that's where you get into trouble with the rape shield law, because now you're trying to show sexual conduct.
No, Your Honor. So the reason that the rape shield law doesn't apply here as to that, and there are 2 other areas in that report that I want to go into as well, but the reason that it doesn't apply as to that is because the rape shield law was designed to prevent the use of a victim's promiscuity to assail her credibility with respect to a report. It was not designed, as this court has stated in Williams and has recognized in other cases, to prevent a defense from being corroborated or forged. And in this case, there was no attempt to assail the complainant's credibility by saying that she self-lubricated, licked her fingers, or licked something and inserted it into her vagina. That was never the attempt, and it wouldn't even work. It doesn't even make sense for a teenager.
It might not have been the intent, but it could have been the effect. And I'm thinking now specifically about the court's gatekeeping function to admit probative evidence that's not unduly prejudicial or would require speculation on the part of the jury. Isn't that's still a valid process?
Well, so what I'll do to answer that, I'll answer it in 2 ways. The first way is I'll flip it around. Let's say that what had been found was the defendant's saliva on her vulva and underwear. There would be no question that that would automatically be relevant to establishing or tending to suggest, it would have been admissible to tend to suggest that he had in fact digitally penetrated her. So the converse is also true. When you have her saliva there, it's equally relevant. And this, by the way, is a test of relevance. So what the rape shield law requires, or what it necessarily does not apply to, is evidence that is relevant to prove defense. Relevant is a very low standard. It means more likely than it would be without the evidence. And then that leads me to the second part. This wasn't just saliva. What we also had in this DNA report was prostate-specific antigen that was found in sufficient quantities to be detected by the Serotac test inside of the complainant's vagina. Now, this was not a case where there was an allegation of penile penetration or anything that would have resulted in PSA. So that was relevant and was excluded. And then finally, there were 2 other men's DNA, not the complainant's, that were mixed in one of the saliva samples from her underwear. So along with her own saliva was a mixture of saliva from 2 other men.
Saliva?
Yes, Your Honor, saliva.
Not just undifferentiated DNA?
No, Your Honor, because it was taken from a saliva sample, and so what makes it conclusive for the presence of saliva other than presumptive was the fact that there was DNA that was recovered from that saliva. So it was a mixed saliva profile of her DNA, of her saliva along with 2 male saliva on her underwear. So this is essentially what was excluded. Now, compounding this error is the way that the prosecution used this evidence on summation. And specifically, what happened here is that once the evidence was excluded, the court did allow the defense attorney to still argue from a commonsensical standpoint that the injuries could have been self-inflicted. However, once the defense attorney did that, the prosecutor argued, quote, these claims were ridiculous as there was, quote, no evidence that she had rubbed or inserted anything into her own vagina. And what the prosecutor said is, now Mr. Gann got up here and he gave you a few alternative theories about that injury, what that trauma to Io's vagina could be. Alternate theories that were never once confirmed, alternate theories that are not supported by the evidence. And then the
Was there an objection made to that comment during summation?
No, Your Honor, but this is not being raised as an independent prosecutorial misconduct point. This is being raised to show how the jury was misled and how the rape shield law was ultimately used not as a shield to protect the complainant, but as a sword to eviscerate the defense.
You're saying it goes to the harmfulness of the error?
Correct, Your Honor. And so ultimately the prosecutor said, this is a direct quote, there is no evidence that she rubbed herself, and that's because it doesn't exist. That's because it didn't happen, because Io did not inflict that injury upon herself. So not only was the evidence improperly excluded, but then the prosecution used it in the most harmful possible way to ultimately eviscerate the defense and mislead the jury as to what actually existed. Excuse me, I'm having a hard time breathing. Can I just pull my mask down a little bit?
Not
Just-
permitted. Why don't you take a break for a moment?
Okay, just for a second to breathe. Okay.
While you're taking that second to breathe, counsel, let's say we disagree with the way you have just articulated this particular argument. I thought you had as an alternative that it was ineffective assistance. Did I miss something?
No, Your Honor. So the ineffective assistance of counsel alternative comes from the fact that to the extent that there was overarching prosecutorial misconduct, not just in this regard, but also in other regards. So I will say this, the record here, I think one of the more disturbing things is that the summation in this case has been described before this court by my adversary as commendable. In over 25 years of practice, I don't think I've seen many summations that were less commendable than this one. This is a case where the prosecutor not only insinuated that evidence didn't exist that she knew did, not just with respect to this, but also with respect to the feces stain on the underwear and other things. But then the prosecutor here actually went as far as to insinuate that 67-year-old Mr. Cerda, who had a spotless criminal record, was actually a serial rapist who had just never been caught before. So this is not a commendable summation. This is a very disturbing, very troubling summation that should be recognized for that.
Counsel.
Yes.
That last statement on the serial rapist, whatever was actually said, that was objected to.
Yes, Your Honor.
And there was a remedial instruction given.
Correct, Your Honor.
So is your ineffective assistance claim then based on a failure to move for a mistrial?
Yes, Your Honor, in part, and a failure to object to the extent that what counsel did was insufficient to preserve any of these issues, or to the extent that what counsel did was insufficient to alert the court to the way that this evidence was being miscast by the prosecution, then that was ineffective. So that is an alternative argument. Under People v. Wright, the court can reach that. Now, I will say that with respect to the serial rapist argument, even though ultimately the court initially said overruled, and then it said, well, I'll sustain to the extent that there's no proof in this case that Mr. Cerda is a serial anything. The prosecutor then immediately jumped on that comment and said, well, we don't know what happened in other cases. We're here to talk about what happened here, which actually I think compounded the prejudice and the error here. I think the counsel overall was forced to try this case with both hands tied behind his back. And that's not what the Rape Shield Law is designed to do. It's not what the Rape Shield Law was ever meant to do or what it requires. And it also it went beyond just the Rape Shield rulings and into rulings that dealt in general with the complainant's character and her basis of knowledge. So throughout this trial, counsel tried on many occasions, I won't go into all of them in the limited time that I have left, but tried on many occasions to point out that this complainant had in fact been exposed to sexting, to sexually explicit material, to allegations in fact in the sexting that specifically referred to digital penetration of her vagina. So that was inconsistent with the prosecutor's overarching argument that this complainant was innocent and that she therefore lacked the basis of knowledge to fabricate these allegations. And so that too was a deprivation that compounded, so to get back, I guess, to the first question, this was a cumulative death by 1,000 cuts that was compounded by a series of evidentiary rulings that ultimately deprived the defendant of due process because it left the jury with a false impression of what the evidence was in this case and who this complainant was. That is what violates the right to due process, what violates the right to a fair trial, and what fundamentally requires this court to reverse and send it back so that before this man, who has been here his entire life, who has built a life for himself in this country with his children, with his family, before he is deported on the basis of these weak allegations to a country that he left as a child, that he doesn't know, he'd at least be afforded the right to do what he has wanted to do from the beginning, to defend himself and to prove with the evidence that exists, compelling scientific evidence, that these allegations are false.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors, and may it please the Court. My name is Andrew Fukuda for the People. Your Honors, the trial court's preclusion of the certain findings in the forensic lab report was proper because these findings were inconclusive, they raised more questions than answers.
What about the serology?
The
Saliva.
The saliva, yes. So there are two findings of saliva relevant here. There was a saliva found on the victim's on the victim's vulva, and also the saliva in the underwear. I'll deal with the victim's saliva on the vulva first. In order for that item of evidence to be relevant, you would have to make two huge leaps of assumptions and speculation. One is the finding of the speck of saliva on the exterior wall of the victim's vagina must mean that she masturbated. That's the first speculation that you have to make.
Why do you have to say that it must mean that rather than it could mean that?
Well, it's relevant, that item of evidence is relevant here in as much as it has a causal link to the particular injury.
That is, it may have a causal link, right? Not that it must have a causal link.
Well, sure, we could say it
Okay.
may have.
All right.
It may have. But the second item here is just that she must have not only have masturbated, but she must have masturbated with severe force and with terrible pressure. Dr. Miller...
Or with an object of some sort.
That's possible, but I mean, Dr. Miller testified at trial that in all of his 19 years seeing over 10,000 patients, he had never ever seen a non-victim teenage patient of his who was sexually active and masturbatory ever display any kind of particular injury.
Why doesn't that then just go to the weight as opposed to the admissibility of that evidence?
Well, I think 6042 subdivision 5, which is the interest of justice clause, it requires the issue of relevance to come in at that point. And I think subdivision 5 is very cognizant of the need to protect.
Isn't it relevant based on when the evidence was recovered from her?
That it is relevant when, I think adding into the mix of relevance as well, is in this case, we don't know who, we don't know how. The saliva, after all, may have been placed upon her vulva in the most innocuous of ways. I mean, there are probably dozens of innocuous reasons why an 11-year-old saliva might end up on her vulva.
So are you suggesting that the defendant must prove that masturbation was the reason that it was there?
No, I think the the defendant must make a valid offer of proof, and that's from subdivision 5, must make a valid offer of proof that is relevant, and that's the calculus that the trial court has to analyze and wrestle with. And finding that a speck of saliva on the vulva of an 11-year-old child does that necessarily connote?
Suppose it had been a speck of the defendant's saliva. Would you be making the same argument that it's speculative and it's got to go through these two hurdles that you can't surmount?
Well, I think those two are dramatically different scenarios. One is an 11-year-old girl has her own saliva on her own body. And then now we're talking about a scenario where you have a 63-year-old man
If the
saliva
question is,
on.
did she harm herself, why isn't her own saliva relevant to that? Whereas if the question is, did the defendant harm her, his saliva be relevant to that?
Well, again, I draw back to Dr. Miller's testimony.
Well, I go
which
back
is-
to Judge Rivera's question. Why isn't that just weight of the evidence for the jury to hear?
Well, I think this goes back to the rape shield law. Again, the rape shield law subdivision 5 is very, very careful in its language when it says this kind of analysis and pre-trial conversation must take place outside of the presence of the jury.
Yes, but the rape shield law is set up, right, to ensure that when a complainant, victim gets on the stand, their character is not attacked, and that's what the jury is reacting to, as opposed to here, where, as I understood the defendant's argument, this would have been to show potential fabrication, not to show, look, she's promiscuous and therefore don't believe her, or therefore I am innocent, or therefore acquit me, but rather there's another explanation for these injuries.
And I think that to reach that other explanation for these injuries requires such flights of speculative fancy that the judge, in this case the trial court, was correct in not permitting these items of evidence in. I mean, we're just talking about the saliva now on the vulva, but with respect as well to the mixture ratio on the underwear, that's also very highly speculative.
What about the argument that after this evidence was not allowed in, the manner in which the prosecutor used it?
Well, I'm afraid that argument is premised on a complete mischaracterization of the record. And in summation, the prosecutor never said that there was, never said there's no evidence regarding petechia or the lack of petechia or saliva.
Did the prosecutor say there's no evidence that she touched herself? That was what your adversary claimed.
The prosecutor was only responding to the alternate theories that was being raised by defense counsel. And those alternate theories have nothing to do with petechia or semen or prostate-specific antigen. Those alternate theories were, one, that constipation caused the petechial injury, and two, that an itchy vagina caused the victim to scratch herself, and that caused petechial injury. So when the prosecutor said there is no evidence as to that, she was absolutely correct. There was no evidence as to that.
Can I ask you about the two male DNA samples from the underwear?
Yes.
Do you agree that those are samples of male DNA from saliva?
Yes,
Is that
the
what the
forensic
report
lab
says?
report found that third stain, there was a composite of both the victim and two unknown and unknowable male DNAs.
And that male DNA was from male saliva? Do you agree with that? Is that what the report
Yeah,
says?
there was two male DNAs found inside that composite, the mixture ratio.
And that the DNA from those two males was from male saliva? Do you agree?
Yes, I would say that's a correct
Okay, all right.
recitation.
I just wanted to see if
of
there was an
record.
agreement about that.
Yes. As to that, I would also quickly note that, again, you have to make a speculative leap to assume that the finding of male saliva, specks of it, in such low quantities that no YSTR DNA test could be found and no profile could be drawn, that must mean that it was through sexual conduct. In fact, the victim in this case, she lived with a grandfather and two uncles in her home, and that's in the record. So those...
Yeah, again, I'm having great difficulty with this because that, again, sounds like a weight of the evidence argument that certainly the prosecutor was free to make and present whatever evidence might support that. But I don't see how it's not relevant or admissible. That's where I'm having difficulty with your position.
Well, I think in the end, the trial court weighed all of these factors. It was weighing all of these different arguments, and it's within the court's discretion at that point. The court is, 6042 subdivision 5 is the gatekeeper to this kind of evidence. And the court has the discretion to be able to allow evidence in or...
Yes, but even that discretion is restrained, is it not, by the right to present a defense?
Absolutely. But where the defense is premised on layer upon layer upon layer of speculation and assumption, and those assumptions and speculations can risk, for example, causing the victim to be embarrassed or harassed by the evidence, then the trial court is well within its right.
Let me ask you, counsel, if the court disagrees with you that this is layer upon layer of speculation, does the defendant win?
No, I don't think so. Because even if we assume, for example, with the prostate-specific antigen, let's assume that that's semen. Even that alone is not exculpatory evidence for defendant. The semen, for example, assuming it's semen, could very well belong to defendant. He may have fondled himself beforehand and it may have been smeared on his finger before he digitally penetrated her. And again, even if it is semen, Dr. Miller has stated that he has never ever seen, except in trauma victims, regular people who are practicing sex display and have this very significant and traumatic injuries or petechial injuries. And here there wasn't just one petechial injury. There was 2 and possibly 3 and also a deep notch injury. So these were 3, perhaps 4 different discrete areas.
Counsel, it sounds like a great summation, but I don't see how you keep the evidence out.
Well, I would end here very quickly. I know my time is up. I would just want to say that the evidence here was overwhelming. In this case, moments after the victim was digitally penetrated, she went into the restroom and locked herself and made an immediate prompt outcry, which is memorialized almost like play-by-play through text messages to her mother. The victim also sent out a prompt warning to her 2 cousins to go to their room and lock the door. We have forensic evidence here, petechia and the deep notch. These kinds of evidence are actually rather infrequently found in sex crimes cases. And we also have a verdict, the jury which came back with a verdict, an overnight verdict very quickly. So I would argue that the evidence in this case was overwhelming.
Thank you, counsel. Counsel, your rebuttal?
Yes.
Before you start, can I just ask you about the DNA on the underwear?
Yes.
What's the process of conclusions or steps that get you to some defense? I guess the defense would be that sexual activity was happening with other men, I suppose. How do you get to that from the DNA on the underwear?
So there was saliva, it was saliva on the underwear, and it was her saliva mixed with that of 2 other males. So even assuming hypothetically that one of those males might have been Mr. Cerda, although I don't think that's a fair assumption when he offered his DNA for testing and the prosecution refused to test it, so I think that that's fairly improper. But even assuming that that were true, it certainly would have shown that she was engaged in something intimate. It was a mixing of her saliva with other men's saliva, and this was not located innocuously on, a place on her jeans or on her shirt. This was located, she had saliva on her vulva. She had prostate-specific antigen inside her vagina.
I'm just talking about the underwear, though.
And
I keep asking myself, well, how could it have gotten there? And my answer, quite frankly, is any one of 100 ways.
Well, but Your Honor, again, to reiterate what Judge Rivera said, that goes to weight. And the problem here is that the jury, in order to make a fair credibility assessment, needs to have this evidence so that they can weigh credibility. Now, leading into harmless error, which credibility does, this was not a case where this was overwhelming evidence as the prosecution has characterized it. This is a case where the jury did not believe the complainant and acquitted Mr. Cerda of touching her breasts, which was one of the other counts. Specifically because, what is the difference? The difference is, in that case, there was no lab report or there was no medical report that showed that she had made that. So conversely, if we have scientific evidence or a lab report suggesting the presence of other people's DNA and saliva on her vulva and prostate-specific antigen inside her vagina, then the jury may well have rejected that Mr. Cerda was the cause of those injuries and may have rejected her account on that as well. Additionally, this was a case where the jury deliberated for 2 days, asked for multiple readbacks, and the victim's account here was by no means credible. This is a girl who changed her account several times within the course of one evening. One evening. On the night of the incident, she changed her report about whether he merely tried to insert his finger or actually inserted it. She changed her report about whether he inserted his finger 3 or 4 times or whether it was for 3 or 4 minutes. She changed her report about whether there was anal penetration or not, whether he touched one breast, both breasts, or none at all, and which hand he used. So you're talking about a very, very weak case that came from a very disturbed and troubled young girl who made a report that ultimately was physically improbable given common experience and the circumstances. The allegation was that the 67-year-old man first assaulted her for the first time in front of his 2 granddaughters while sitting together on a couch. Now, I can't get into off the record.
Look, counsel, let me interrupt you. If defendant proffers what defendant says is proof of an alternative theory, can't a court conclude that it has absolutely no basis? There's no way for a jury ever to make the same conclusion that the defendant wishes to argue, which I think, I may be wrong, but I think that's what your adversary is arguing. There's just an implausible theory. Nothing supports it.
Your Honor, everything supports that these injuries were caused by some other, or could have been caused by some other source than Mr. Cerda. And what's more is, again, this was not the innocent complainant that the people tried to show that she was. This was not a young child with no basis of knowledge or experience to fabricate these allegations because she had never seen or experienced anything like this before. Everything in this record supported that this was a sexually experienced young girl. She was disturbed, that may be, but this is the defense. The defense is that these injuries do not corroborate her account, and the jury needs to know that for credibility. I would also note that with respect to Dr. Miller's report, which my adversary has talked about, the jury is free to disregard an expert witness's conclusion just like any other witness. In this case, Dr. Miller said, or he concluded, that the 2 petechia, these are pinhead-sized injuries on a hymen, that were observed in this case could have been and were consistent with insertion of defendant's finger into her vagina, but were not consistent, my adversary argues, with insertion of anything else into her vagina. That's just not reasonable. The jury is free to reject that. They did not reject it in this case because the prosecutor, when the defense attorney argued that on summation, the prosecutor retorted, "We have no evidence of that." And on that, I do need to address what my adversary said about the fact that allegedly I've misrepresented the record. I did not misrepresent the summation at all when I talked about what it is that the prosecutor did or said. The prosecutor called the defense arguments ridiculous, and specifically, this is at page A40, A43, and A45, talked about the alternate theories about what the trauma could have been, said that they were never confirmed, that they were, quote, not supported by the evidence, that all of the evidence in the record contradicts the theory about the petechia being caused by self-inflicted rubbing, because there's nothing in the medical record to support that, and then concluded there's no evidence she rubbed herself, and that's because it doesn't exist. That's because it doesn't happen. This evidence did exist. And Your Honors, on that point too, the feces. The feces is very relevant here because it's yet another example of the same type of conduct or misconduct by the prosecutor in basically distorting the truth here based on a ruling that she obtained from the trial court. So in this case, the defendant himself and his granddaughter testified that the complainant went to the bathroom and locked herself in and claimed that she was having stomach problems. And so the feces on the underwear, and I would direct this court to look at a picture of the underwear that was put into evidence. This is at A319 in the appendix, that the feces on the underwear, which was a pretty large, substantial stain, in this case was consistent with the defendant and his granddaughter's testimony on this point. And it also would have corroborated the fact that there may have been a source of irritation. The prosecutor succeeded in keeping out evidence that the stain was actually feces. And then when defense counsel attempted to elicit that it was feces from the prosecution's expert, the prosecution elicited from that expert that this, in fact, might have been playground dirt. This is after the prosecutor admitted that in the DNA report she had excluded, there was confirmation that this was a feces stain. And then on summation again, she argued that there was no evidence of any kind of feces stain, that we don't know what the stain is, which was simply false.
Thank you, counsel.
Thank you, Your Honors.